Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our twice a month or bi-weekly telephone call for the community. You would have heard our disclaimers when you logged in. Those apply. Not attorney-client relationship and not guaranteed information. We do the best we can. Let me just make sure that you guys can hear me. Let's double check that.
The conference is now in conversation mode.
Can you all hear me, folks?
Yes, sir.
Excellent.
Yes, yes.
Thank you.
The conference is now in presentation mode.
Okay, folks, at the outside, I just want to note that we have a few more questions than I normally have time for. We'll finish everything that has been posted and any follow-ups, but I'm not going to have time today for new questions. Let's begin with the frequently asked questions first. This is from Gursik133 about applying for a B2 during this COVID time. So the question is, I came to the US on H-1B. I-140 was approved, joined a new employer, H-1B got approved, but did not receive any receipt notice for my wife and my elder son for H-4. Employer said they had applied for H-4. Then he got laid off due to the COVID-19 situation. They informed USCIS on 8th June to revoke his visa. My priority is to find a new job, but in case I do not find any job, I would like to move out of USA. I do not want to accrue unlawful days, but due to the COVID-19 situation in India, I'm scared to travel to India. The way I look at it, of course, folks, health is always first. Whatever is good for your health, you should go for that option. Immigration consequences, while undesirable, I don't see how they can be avoided if health is paramount. I also want to note that this may be some misunderstanding people have. First of all, let's begin to count your status days. So when you're on H-1B, you've got 60 days or the time remaining on your I-94, whichever is shorter. So if you have 35 days remaining on your I-94, you don't have a 60-day grace period. You have a 35-day grace period. So the time remaining on your I-94 or 60 days, whichever is shorter. If you start accruing unlawful presence of up to 179 days is not going to hurt you. Only when it hits the 180 mark, that's when it becomes a 3-year bar. And there are waivers available, something called a 212D3 waiver. That waiver can operate simultaneously with your green card. So it's not a desirable situation to be in, but it's not the end of the world. So remember, up to 179 days is not going to harm you. It can only hurt you for visas like tourist visa and student visa. It has no effect on H1, H4, L1, L2 type visa, which are dual intent visas. Okay, so I'm not that concerned about unlawful presence if push comes to shove. Avoid it if you can, of course. Unfortunately, you do not have a receipt number for your wife and your son. This puts them in a very awkward situation. Okay, so what I would want to know, and if you are on the phone, press *5 if you're on the phone, because I have a question I want to ask you. That could be very important. Okay, excellent. Hi, good afternoon.
Good afternoon, sir.
Yes, sir. My question to you is, when did their H-4 expire, the last H-4?
I have the receipt notice. The H-4 expired in December 2019.
19. Hello?
Yes.
Okay. So
And Yeah, and I have the receipt notice now.
You
I
have
called
the receipt.
USCIS. They
Okay,
provided
good.
me the receipt notice.
Good.
Yes.
So the good news is, as long as their H4 is pending, they are not accruing any unlawful presence. Okay. Was the H4 filed by your lawyers?
It's the company lawyers.
Company lawyers. Well, company lawyers are representing you as well. So make sure you reach out to them and tell them all correspondence relating to your wife's case, your son's case, and your case should be forwarded to you at XYZ email address. Make sure they have your most current mailing address if necessary, but email for sure. Okay? Because what I want to know is from which date is their H4 denied? Because eventually their H4 is going to get denied. That's what I suspect. Okay? As long as it is not denied, they're not accruing unlawful presence. But unfortunately, they are also not in status. They are in between statuses. They are legal but not fully in status, while a timely filed H4 is pending, but the previous H4 has expired. Are you following me?
Yes, sir, I am following you.
Okay.
I am following you.
Okay. So, therefore, what do you do from a planning perspective? What you do is you file for their B2 also, but start counting 180 days from the date their H4 is denied by the government. Okay? So once the H4 is denied, unlawful presence begins for them. For you, unlawful presence begins on that 60-day I-94 remaining, whichever is shorter period. So yours is easier because you can always file a B2. Theirs is more difficult, but file their B2 anyway. It's a good idea. I was with the IT Sub Alliance conference call yesterday, and the same question came up. And I said, even if you are out of status, at least file something so that if tomorrow we end up in court over 3 or 10-year bar, I can at least argue to the court or even to the USCIS from a settlement perspective that we had something pending that could be approved. So if you settle with the government, if you don't have anything pending, what are they going to approve? Okay. So therefore, your action items are, number one, reach out to the lawyers, explain to them what is happening, and tell them to make sure you get copies of everything. Number two, file for your family's B2 if your H1 is not filed within that 60-day I-94 time. Okay. If it is filed, go ahead and file another H4 application with them. With that filing, I think it's a good idea because I don't know where the previous one is going to go. There are several legal issues there. Are you clear so far on action items?
Yes,
okay.
I'm clear.
Let's take a quick look at the rest of your questions. So you said, should I include my wife and my elder son in the I-539 for B1, B2? The answer is yes, if you are not able to file an H1, H4 for them. Okay. Question number 2. What will happen to the pending H4 if we leave? No problem. That is considered to be abandoned. Now you have a receipt notice. Even if you did not, you're fine. So you can leave anytime you want. Okay? You with me so far?
Yes.
Okay. Third question was, is there a possibility that after applying for the I-539 change of status, we have to wait for the decision for months? Oh yes, absolutely. And you can stay until you get a B1, B2 decision, or the time you have requested in the B1, B2 is about to end. So if you ask for 6 months, you can't stay here for 10 months. You have to leave within those 6 months or apply for another extension while the first one is still pending. Okay. Can I apply for EAD under special circumstances? I posted yesterday, or I reposted from my blog, an infographic I had drawn explaining the entire compelling circumstances EAD in one graphic. So if you go to either my blog or go to my LinkedIn page, you can see that graphic. And the answer is, broadly speaking, compelling circumstances EAD is quite advantageous, especially in the times of COVID, but it's not a perfect solution. Why is it not a perfect solution? Number one, if you go on to the EAD, you are no longer in status. If you wanted to get back onto H1, you would have to get the H1 approval and go get a visa stamping. Okay. Secondly, it's only given on a year-to-year basis. You have to keep applying for extension every year. But the advantage is your wife can also get an EAD. Okay. Any follow-up questions? Are you done? Are you all set? Okay. Good luck, sir. Guys, anybody has any follow-up questions on what I just discussed? Press *5. Any follow-up questions on what we just discussed? Okay. Let's go on to the next question. Oh, there is one. This is from area code 719. Where are you calling from, 719?
From Virginia.
From Virginia. Okay, ma'am. How can I help you?
I just want to know how to calculate this grace period. Does it start from your last working day or your end of severance or your end of payroll?
Okay. So the answer to that is, I am not sure this is clear, because there are many areas in law that are quite fuzzy. This is one of those areas. So what do you do when you have a fuzzy area? You take the most cautious approach. What is the most cautious approach? You count from the earliest of the three you just mentioned. The date you stopped working, the date you stopped getting paid, and what was the third one you said? I'm sorry, I lost track of that.
Severance.
Or severance pay. Okay. So normally what happens is severance pay is not considered to be salary, but it's so difficult to distinguish between severance and regular pay. Personally, I think that as long as you're getting paid your regular pay, not your severance, your regular pay, you are in status even if you have stopped working. So if the company puts you on bench and starts paying you a bench salary, which is full salary, you are still in status, and your 60 days will only begin to run upon the conclusion of the payment period. Okay. But if you are in doubt, always count from the earliest date. You okay?
Okay. Thank you, sir.
Good luck. Okay, guys, let's move on to the next question. So this also comes up quite frequently. Working from Canada on or off H-1B. So let's say I'm on H-1B. I've got 2 years remaining, but my permanent residence for Canada is approved, or I have a temporary work visa in Canada. I want to go live in Canada, but I want to work for my American company. First question, do I have to maintain my H-1B? Not really. But what if I have to come to USA every few weeks? Sure, then maintain your H-1B and make sure that at least for the time that you are in the United States, you're getting paid the salary according to the terms of your H-1B, including withholding, etc. While you are outside the USA, are you required to be paid according to the US or the terms of your H-1B? Probably not. There is some doubt there, and I think there is a badly decided case which should be overturned on appeal, where the Department of Labor administrative law judges said H-1B terms can apply even if you're outside the United States. I think that's crazy. I think that needs to be overturned. But that is one of the decisions. So in my view, you do not have to maintain the terms of your H-1B outside the US. But if you're not going to come back at all, you can let your H-1B go. You're not subject to the H-1B quota for 6 years at least. So why worry about it? You can always come back on H-1B if you want. And your green card can go on in your absence as long as the job offer remains, the ability to pay wages remains, the company is making enough money, you are fine. Okay, let's take a quick look at your questions. Can I stay in Vancouver while I commute to Seattle for work once a month for a day? Sure. Any restriction on the amount of time I need to spend inside the US on H-1B? No, no restriction. In fact, there's something called an intermittent H-1B, which means if I am gone for more than 6 months in any 12-month period, that whole 12-month period doesn't count. So think about this. If you're outside USA for 4 months, you can recapture 4 months. But if you are outside USA for 6 months and 1 day, you can recapture the entire year. Okay? And if you want to come, I had a client we did this for as an experimental basis. We were actually getting ready to file a lawsuit for him, but luckily Congressman's office stepped in and corrected the situation for us. They are a fairly large manufacturing company. He's their general manager, and we had sent him through their operation in Japan to bring him back in on an EB1C, which is a international manager. So while he was in Japan, he was holding an H-1B, and he came for about 3 weeks intermittently during that 1 year he was outside Japan. Now, when I applied for his H-1B, or was it L1 extension? No, L1A extension, or L1A to H-1B conversion, the government gave me a hard time saying you have only X number of days, and their calculation was incorrect. So I pointed out to them that intermittent H-1B, the whole year cannot be counted. But in any case, they refused to accept it. We were getting ready to file a lawsuit when the congressman's office informed us that day before yesterday, the government had reconsidered their position, and they had issued a new notice with complete approval as we had requested. So the point is that there are, in this H-1B working outside USA, there are certain cardinal principles. You're not required to maintain an H-1B if you don't want to, but if you want to travel to the USA on H-1B, you should maintain it, and you are required to be paid according to the US standards only the days you are in USA. When you're outside USA, at least my opinion is, you shouldn't have to be paid according to the H-1B standards, although there is a Department of Labor decision which I find quite silly. Okay, so let's see, did I miss anything here? No, I think I covered this part. Any amount of time I need to spend inside, outside? No. Since my work location would be changing to Seattle from California, my perm will need to be refiled. No, not really. It depends upon how the perm was filed. This is a long discussion. You should talk to your lawyers. It's hard for me to spend the amount of time that we need to go over each aspect of it, but we'll have to look at the perm. If it was appropriately filed, at least what I consider to be appropriately filed, you should not have to redo it. Okay. Can my current company use an older existing approved I-140? Yes, of course. My older I-140 had been approved for more than a year, as long as at least 1 day of that approval period was on or after January 17th, 2017. So if your I-140 stayed approved for 180 days, yours is more, 180 days, and at least one of that 180 days fell on January 17th when the regulation came into effect. So if your I-140 was approved for 179 days and the 180th day was on January 17th, you are good. If the 180th day was before January 17th, 2017, it's debatable whether that I-140 is any good for you. If you meet the requirements that I just mentioned, your new employer can use an old I-140 to extend your H-1B. There should be no impact on your H-1B renewal. You would, of course, have to go for stamping if you need to come into USA. Do you need a US address? Not really. Site inspections? That's fine. Just completely disclose to them what you are planning to do. That's what I do. I always disclose fully to the government what we are thinking. And yeah, thanks for the good wishes for the good karma. Appreciate it. Any questions? Press *5. Any questions? Press *5. Okay. So this is from area code 209. Where are you calling from? 209?
I'm calling from California.
Yes, sir. Go ahead. What are your questions?
Thanks a lot for doing this community service. It's
Absolutely.
really helps.
My pleasure.
So from what it looks like, I think I should be good, and there should not be any issue with this. But I just suspect that when it comes down to a renewal, is there definitely no problem with that?
Well,
considering that
look,
I also looked at my petition.
Look, hang on. There is no problem in theory as well as in practice. It isn't like it's the first time we've dealt with this situation. Okay, because not only do we know in theory this is good law, we know in practice it works because we've done it many times before.
Understood.
Okay.
So as long as I fully disclose this to my employers and my employer discloses to the government, and we kind of keep it as transparent as possible, we should be good.
Always. Absolutely. Yes, sir.
Understood. I just had one more question. This is probably something which came after I posted this, and I know that there is right now there is a wait for this new immigration new executive orders about a new immigration law, something called as merit-based immigration.
Well, he can't do that. That's not something that's not something Trump can do unilaterally. Congress has to do it.
Understood. So, I mean, the question which I basically had was, can the government go ahead with something called as merit-based immigration, but still do the 7% cap? Because in my view, that itself is not merit-based immigration if you have a 7% cap and you call it merit-based immigration.
Well, I don't think so. I think that would be unlikely. I don't remember the last comprehensive immigration reform, which was close to 1,100-1,200 pages, all of which I read. It passed in the Senate, it bombed in the House. That was merit-based, and I think they had removed the per country limit in that. We can expect kind of a mirror image of the same thing happening. By the way, Mr. Biden, Joe Biden has said that he intends to remove the per country limits.
I see.
Okay.
So I guess yes, I guess that answers everything from my side.
Good
Thanks
luck.
a lot, Rajiv.
Anytime. Good luck, guys.
Thank you so much.
Bye. Okay, let's move on to the guys. For those who are just logging in, I won't have time for new questions today. We are pretty full up. Let me see if there's any more frequently asked questions. Okay, here's one. And that actually segues nicely into what we were discussing a moment ago. How can I qualify for EB1C international managers executives? So for those of you who are uninitiated in this jurisprudence or the law of EB1C, the way this works is the fastest employment-based immigration category is EB1, right? You have EB2 and EB3, you see them all the time. But EB1 is the fastest, and it used to be fastest by far. Not as much anymore, but it's still quite fast as compared to EB2 and EB3, maybe half the time, maybe less. EB1 comes in 3 flavors: EB1A, EB1B, and EB1C. We are going to discuss EB1C, but I'll briefly touch on EB1A, extraordinary individual, where you have to meet 3 out of 10 quantitative criteria. Have I won any international awards? Do I have any publications which were heavily cited? Do I have I acted as a judge of my peers? So there are quantitative criteria. I have to meet 3 out of 10. In addition to that, I have to go through a qualitative evaluation by the government. So both the quantity and the quality of my work must prove that I'm one of the top 10% or so people in my profession, nationally or internationally. We have filed a lawsuit against this very artificial division. We think that once you meet the quantitative criteria, that should be sufficient. But there is a case from the Ninth Circuit in California, Court of Appeals, called the matter of Kazarian, where the court decided no, two-step analysis is okay. I think it's not. We'll see what the DC courts have to say. So that lawsuit is currently pending. EB1A, extraordinary ability individuals, hard to win. EB1B is for researchers and professors, people who have those kinds of jobs, and you can be a researcher in the private industry as well. And EB1C is for international managers and executives, which is what I want to focus on. EB1B is usually a lot easier than EB1A, but you need a specific kind of job. EB1A doesn't even require a job offer. Okay, so you can do this even without having a job. We do it for people in different countries who are exceptionally qualified all the time. So I think we did just one recently for a professor in India. She had, trying to remember her qualifications, I think she was a cybersecurity expert. I could be wrong. There was another one who had set up the entire Aadhaar card thing for the databases for the Indian government. So we've been able to do these EB1As, some of them for people who are still outside USA. They have no job offer in USA. EB1 and national interest waiver don't require jobs. Okay. EB1B requires a job, EB1C requires a job. Now let's look at EB1C. EB1C says, I have worked outside the United States for 1 year for a branch, sister, subsidiary of my US company. IBM India, for example, I was a manager or an executive, and now I'm coming to USA to work for IBM USA. I can get an L1. Remember, L1 has no quota. It can be premiumed. So potentially in 2 weeks, you could be here. L1A is good for 7 years total. And you can apply for an EB1C even while you're outside USA, or you can come to USA on L1 like you do on H1B, then apply for an EB1C. So that's why people like EB1Cs, because they are quick. Okay. What is my success rate of getting L1A? We do it all the time. We are right now processing 2 cases exactly with the same fact pattern. I think I mentioned one of them went to Japan for 1 year. The other one went to UK. We may have more, but these are the 2 I can remember off the top of my head. So this is done all the time, but please discuss your job description that is intended in the foreign country outside USA with your lawyers. Make sure you plan for it from day 1, because if you try to plan for it a year down the line, you won't succeed. I think I've covered here. What is the success rate? Planned well. Planned well is pretty good. Do I need to reapply my green card in EB1C? You can apply in EB1C and then transfer the priority date from another case. No problem. EB2, EB3 can be transferred over. You can come on L1A. You should definitely at least get your EB1C started as quickly as possible. That's my opinion. There is no visa ban in starting the application. *5 if you have a follow-up question. *5. Press *5 on your phone if you have a follow-up question. Okay. Let's see if there are any frequently asked questions. Today I marked fewer questions as frequently asked. Let's see. Normally I have 6, 7, 8. No more frequently asked questions. Let's go back to our regular questions. So going back to posted question number 4, I guess. Yes, 4. Priya M360. Currently on H1B, got laid off because of the COVID nonsense. Initially working for employer A from 2008. I-140 was approved, but it was revoked after resignation in 2016. Priya, there is a lot of argument whether you can carry your priority date, not carry your priority date, because before 2017, the government flip-flopped a lot. I was on H-4 EAD, employer B applied change of status from H-4 to H-1B. Employer B using employer A's revoked I-140 got approval. You shouldn't have. In this process, got RFE saying my yes, correct, not eligible. You got the approval, odd, because the only way you could use AC-21 is if your 485 was filed. So I'm not sure. Like I said, government flip-flopped a lot before 2017. Now I have employer B's I-140 approved in June. I've requested employer B not to withdraw I-140 till the 60-day grace is over. Okay. It'll be nice if they can leave it in play for 180 days, Priya. That would be great. Because if they leave it in play for 180 days, you, of course, from January 17th, 2017, the law is you keep your priority date the moment your I-140 is approved. There's no 180-day waiting time. But in addition, if the I-140 stays approved for 180 days, that same I-140 can be used to extend your H-1 beyond 6 years with any employer, even if the H-1 is withdrawn, even if the I-140 is withdrawn. Questions. Can employer B withdraw approved I-140? Yes. Does AC-21 rule apply even though it is within 180 days? Well, AC-21 rule only applies if you have a 485 pending. So I'm not sure what we are referring to here. If you are on the phone, press *5. Okay, good. Area code 719. 719, where are you calling from? I have another hand up from 337. 719, where are you calling from?
I'm calling from Virginia, sir.
Oh, okay. Are you the one who posted this question, ma'am?
Yes.
Okay. So my question to you is, you keep talking about AC-21. Had you filed your 485 already?
No, sir.
Okay.
I was talking about the portability.
See, AC-21 has two prongs. One helps you extend your H-1B. The other one helps you transfer your green card from one employer to another. So one impacts H-1B, the other impacts the green card. There is no AC-21 rule that protects an I-140. However, arguments can be made that the law that became a regulation beginning January 17th, 2017 should be applied to cases that arose before the regulation came into effect. Not because the regulation applies to those cases, but USCIS policy used to. Personally, I think it's a very weak argument because the regulation during those times did actually say if your I-140 is revoked, it cannot be used to extend your H-1B. Okay, so the current I-140 would be very helpful to you if it stays approved for 180 days, not 60 days. And there really is no need for the employer, nor is any law requiring them to withdraw your I-140 immediately. They can let it stay approved for 180 days. Does that make sense to you?
Yeah, but they are going to withdraw. That's what I heard.
Then you will keep your priority date from that case, but you will not be able to use it to extend your H-1B based upon that I-140 for another employer. Okay. Now the question is, can you use employer A's, the previous employer's revoked I-140? In my opinion, no, but you seem to have been able to do it once. You can try again. Okay. What other options do I have to stay in the United States? You can try filing, well, that's the only other option you've got. You can file for another green card through another employer and eventually use that to extend your H-1. Are your 6 years already over, ma'am?
Yes.
Okay. Yeah, so you've got a problem because you will not be able to, I think, use even employer A's I-140 to extend your H-1B. Okay? Sorry about that. But that's the way I see it. You can try, but I think you'll have a difficult time. Good luck.
Okay.
All right, bye-bye.
Okay. And where can I get the documentation for B1, B2?
Documentation, you mean the forms?
Yes.
Oh, online, USCIS website, Form I-539. Actually, you can even file online electronically. You don't need to download the form. Okay.
And is there any blog in your site which I can follow? What all documentation is needed?
I have quite a few discussions in our frequently asked questions, and also there might be 1 or 2 entries on my blog about B1, B2. But if you read the instructions on the Form I-539, they're quite clear, I think. Okay.
Okay. And do we need to write a cover letter for that?
Ma'am, read the instructions. If you have any questions, come back in 2 weeks. I'll answer your questions as best as I can. Okay?
Okay, sir. Thank you so much.
Good luck. Yeah. Area code 337. Go ahead.
Yeah, sir, actually I am here on L1 visa and my I-140 has approved in 94 days.
Okay.
And my daughter has aged out in July 10th,
okay,
2020.
Okay.
And my priority date for this green card, this I-140, this priority date is 2nd of October 2018. And recently this
look, the calculation is hang on. The calculation is intricate because whether you use the filing date or the action date, there is all sorts of debate there. I'm not going to be able to do it here.
Yeah.
Okay. You can talk to your lawyers, but essentially, you have her birthday, her 21st birthday, plus 92 days to file for the 485. If you're not able to do it in that time, she will age out. You will have to apply for her separately. Okay?
There's plus 92 days.
I can't.
Any other possibility?
No, I can't get into the details of the calculations with you. That's too complicated and too long for me to discuss here. Talk to your lawyers. They should be able to help you out. Okay?
Okay. Thank you, sir.
Bye.
Thank you.
Okay. Yeah, CSPA calculations can get a little complicated. Simple question. Can I day trade on H-1B or my wife on H-4? The answer is no one knows. So I always think of day trading as an active business rather than a passive investment. I think if USCIS were to find objection as active, let's rephrase that, as actually doing business instead of just passive investing, then definitely day trading would be as close as they can get to your Wall Street investments. So the answer is really to your question, we don't know. Government has never spoken about this definitively. I don't have much else to add to that, so I'm not going to invite further questions. Member 24, I'm on H-1B, I-140 approved, 6th year extension applied. Petition is valid till July 27th. I-94 is till August 3rd. RFE. What happens if my status gets denied? My spouse is also in H-1B with PERM going on. Can I go from H-1 to H-4? Yes, you can. I have seen, I did a, I don't think it was a consultation. I think it was in one of the community calls. It may have been with IT Serve yesterday. Somebody brought up this issue. No, I'm sorry. I'm wrong. I did a consultation only today, actually. What happened was that gentleman's H-1 extension was applied within the 10 days grace period given on his I-94 following his H-1B completion. And the government came back and said, oh, no, you were out of status. So I told them, I said, you should definitely sue the government because the regulations appear to be quite clear that you have a 10-day grace period within which you can change status. Okay, so that would be my interpretation, but I've seen the government try to push you the other way. I think they're wrong. So you can apply for a change of status. Just remember, your application must be in the hands of the government within the life of your current I-94 plus whatever 10 days they've given you. Okay. After August 3rd, if I have both my H-1B and H-4 application pending, what status will I be in? I have done a frequently asked question on the difference between status, authorized period of stay, out of status, and unlawful presence. So to cut the long story short, you will be legal to stay in the United States while these things are pending. Can I withdraw the change of status to H-4 once my H-1B is approved? Hypothetically speaking, I don't see any problem with it. But do discuss with your lawyers. If my H-1B is denied, and if I had applied change of status to H-4 with the decision pending, can my employer still apply for another change of status to H-1? They can try. But the problem is, if there's a pending application, this is the second lawsuit we have pending on this also. The question there is, if you have a previously pending H-1B extension and they approve your H-1B transfer, your original status has expired. My contention is they should still give me my status within the United States. Government has declined it. I think they will lose this case. Why? Because the language of the regulation in this case is very clear. Your case, the language is not clear, but discuss it with your lawyers when the time comes. It certainly is theoretically possible to ask for a change of status. I don't know if you will get it, even while the previous application is pending. Star 5 if you have a follow-up question. Star 5. Okay. Area code 224. Where are you calling from?
Hi, I'm calling from Chicago. I have a follow-up question on this. So you said it has to reach the USCIS before the I-94 expiry date.
Yes.
The receipt
Yes.
notice should be available, or
No,
the
no.
FedEx number?
The FedEx number, the physical proof of delivery.
Perfect. Okay. Thank you very much.
You're welcome. Good luck. Okay. So, did I just do this one? Oh yeah, I just did this one. Go on to the next one. Rajnikant, the film star, has left us a message. Current H-1B second term is expiring on January 2021. Current H-1B second term. Due to recent layoffs, company had to postpone filing of perm to September 2020. Number of months remaining on the first 6 years of H-1B is 5 months plus 90 days outside the country. Can my company apply for H-1 extension for the remainder of 8 months? Oh, absolutely. Absolutely. The law is, or the process is, you can apply for even 4 days remaining on your H-1B. That's not a problem. But here's the interesting thing. Let's say that I filed my perm application on, let's say on January 1st. Let's say on June 1st, it's been pending 6 months. I don't know how to describe this. So, but I'm going to try my best. Or let's say it's 6 months on June 1st. Technically, I'm entitled to 1 year extension on December 31st. 1 year pendency of perm application. But if I have 6 or 7 months remaining to recapture, I can actually file my application in June itself to be effective for recapture of 6 months for the time I was outside, plus 1 year because my perm will be pending 1 year from December 31st. So you can actually combine recapture with an extension if there is no gap between the two. If there is a gap between the recapture time and 1 year anniversary of your perm application, you could leave USA for a few days until you're entitled to the 1 year extension. So yes, they can apply for an extension for the remainder also, and they can combine it if that brings you to September of 2021, which I think it does, or maybe it doesn't. *5 if you have a follow-up question. *5. Okay. Singman says currently on H-1B approved I-140 and current petition, I guess that's the H-1B, valid till October 2022. Spouse is on L-1A. Current petition is expiring in October of this year. I-94 is good till 2nd Jan of next year. Her 7 years are maxing out on 14th February of next year. They're going to recapture the remaining months until 14th Feb. They are filing green card in EB1 category. Given the time remaining, she'll be approved, we are hoping. Given the COVID situation, I don't want to take chances. I also want to file for her H-4. Can we do both? Extension of L1 as well as H-4? Yes, you can. No. You are assuming incorrectly. You can file both. I would file the L1 extension premium and the H-4, of course, there is no premium. As soon as you get an answer, you know you got the L1. You can withdraw the H-4, or you can even actually wait to file the H-4 if you have enough time. Yeah, you seem to have enough time. So in other words, that's possible. Once company files her I-140, can she still change her status to H-4? Yes. Yes, I-140 has no connection with her H-4. Does she need to be on L1A throughout to get her green card? No, the answer is no. EB1C green card can be obtained whether you are on H1, H4, L1, L2 or outside USA, as long as you qualify for it. Since we are, does she need to, okay, you can do an adjustment of status if you are maintaining good status. So if she is on H4 and her L1 is approved, her EB1C is approved, the dates are current, she can file for adjustment of status from H4 to EB1C, no problem. Since we are filing for change of status to H4 from 24th October, can we still choose AOS or opt for consular processing? In your case, I would probably opt for consular processing, because you can always file 485 even though you opted for consular processing. Okay. And she can use the priority date even if she leaves USA for 1 year or 10 years. Priority dates are supposed to be good forever until the laws are changed. *5 if you have a follow-up question. *5. Okay. So you are, I think, Tim, what you've said is that you're going to sue the DHS. You've sent intent to writ. There's no such thing. You're not required by any law to warn the government you're going to sue them. You can just sue them. I wouldn't call them or anything. I would just take it to court. Okay. *5 if you have a follow-up question. Excuse me. *5 if you have a follow-up question. I'm losing my voice, guys. Abhipur, next question. My visa and online I-94 good till August 28th. Current petition with the employer X valid till July 3rd. And I-94 is good till July 13th. Working with a client, contract valid till July 10th. Looking for a new assignment. Which I-94 should be considered valid? The one that's the most recent, in my opinion. The one that's the most recent should be considered to be valid. Can they give you salary without filing an extension? No. Well, let me rephrase that. If the employer just wants to give you money, they can, but you can't work for it. There are two circumstances under which you could be paid a salary or any amount of money. One, if it is for work already done. So let's say you had a yearly bonus coming, but your work authorization expired. Can you still in February or March be given the bonus for last year? Yes. Even though you don't have work authorization, it is money coming to you for work already done. Second situation is where you're not working, but the employer just wants to support you. That's okay too. Even if your EAD has expired, I don't see why you cannot take money if somebody wants to give it to you. You're not working for it. What can be the impact if my current employer files the extension after July 13th? It will be consular most likely. You can try to argue for exceptional circumstances beyond your control, but it probably will be consular processing. *5 if you have a follow-up question. *5. Okay. Area code 614, where are you calling from?
Sir, I'm calling from Ohio.
Yes, sir.
Cleveland, Ohio.
Mm-hmm. What is your follow-up question?
Sir, so my for the first question you told answer for the first question you told that it should be the recent one.
Mm-hmm.
So in my case, can it be the 28th August, because that is the
there were too many facts for me to keep straight, so I wasn't sure which I-94 was issued at one time, but the general rule is the one that's issued the most recently. So you said online is valid till August 28th. I don't know what date was that issued. So whichever is the most recent is likely the one that you will go with. But this needs to be discussed with your lawyers unless there is something here I don't know. So that's the normal rule. Okay?
Okay.
What else?
Okay. And for the third question, sir, you said that it might go to the consular process. So that means that I need to go outside.
Yes.
For,
yes.
Getting my
yes. And also
okay.
must not accrue.
Okay.
Hang on. Must not accrue unlawful presence, which will begin after the I-94 expires. So watch out for the 180 days from the date of expiration of the I-94. Okay.
Okay.
What else? Are you all set?
Yeah, I'm good.
Good luck.
Yeah.
Okay, let's go on to the next one. So here the green card is expiring in about 1 year. How can I get a temporary stamp on the passport that allows you to stay, work, and even travel actually? Now the usual procedure used to be that you would make an appointment with the local USCIS through the InfoPass system and get your passport stamped. It would say processed for I-551, temporary proof of permanent residence. And that was as good as a green card to work, to stay, and to travel. Current N400 is 1 to 3 years. If I decide to file an N400 and the green card expires before the N400, the process for getting the temporary stamp is the same. *5 if you have a follow-up question. *5. Okay. Area code 571. Where are you calling from? Yep. Where are you calling from?
Yes. I'm calling from Rajiv.
Okay. Go ahead.
One quick question. How do you more severe traffic violations, if at all they do, affect the chances of N400 getting approved?
Well, there are two kinds of traffic violations.
For example, like some states have reckless driving,
Right.
traffic violations.
Right. And I think there's another question like that. Look, if your driving violation is a criminal offense, it has to be looked at very carefully. If it is just a civil violation, just a traffic violation, it should not be a problem unless you have too many of them, because then it becomes, for an N400, a good moral character issue. Okay, so if you have 35 speeding tickets in 1 year, even though none of them is a criminal violation, combined the 35 of them show that you are just a person who's careless or given to breaking the law. Government can use that as evidence of bad moral character. So there is a tree of decision. Is it a criminal violation? No. Go on to the next one. Is it a traffic violation? Good. We should not have a problem unless you have too many of them. Okay? Sir?
Okay.
All right.
If it is something like misdemeanor,
misdemeanor is a crime. Misdemeanor is still a crime.
Yeah.
Okay? So misdemeanor doesn't get punished by X number of months. There's all kinds of problems there. I would not like to comment in the abstract beyond what I just did. If it is a criminal violation, talk to a lawyer. If it is just a civil violation, traffic violation, just make sure there's not too many of them. Okay?
If both are filed, N400 and I-90, let's say N400 earlier and I-90 later, if I-90 is denied for whatever reason, can I stay in the country after expiration?
What is the reason for denial of an I-90? I-90 can only be denied for non-payment of fees, etc. If they want to take away your green card, they have to put you through immigration court system. They can't just take away your green card during the I-90 process. Okay?
Okay.
It's like you can think of an I-90 renewal more or less like a routine renewal of your driver's license. So normally they can't just take away your driver's license without a hearing. Same way, they cannot just deny your I-90 because you have violations. They have to take you to immigration court. Okay?
Right.
Good luck to you, sir.
Okay. Thank you very much.
You're welcome.
Thank you.
Anshuman says, I'm the primary applicant on the I-485. Received mine and my daughter's green card recently without an interview. But wife's I-485 case has been transferred to the local office. She has a disorderly conduct arrest record, which she disclosed. So again, I just discussed that a second ago. If the disorderly conduct was a conviction, and then we have to look at whether it was a misdemeanor or a crime or a felony. And if it is a felony, did she get punishment for 6 months or more of prison time, whether it was suspended or not? So you get into all that analysis. So I still think you should go ahead and get yourself an opinion with a lawyer. Preferably go to a lawyer who practices in the state where the 485, where the offense occurred, simply because there can be so many local flavors to a particular crime. I remember I was asked to give an opinion on a Pennsylvania crime. The attorneys assured me that Pennsylvania had a statute for diversion under which you never had to admit any elements of the crime. And I said, well, that's very important. Find that out. They told me no. When I still insisted on looking at the statute myself. And when I look at the statute, it was quite clear that that diversionary program was an implicit admission of guilt. So therefore, the idea is that there are 50 states with 50 sets of criminal laws. So you really want to talk with a local lawyer who preferably is in deportation, etc. area. They would have better knowledge of the criminal statutes applicable to the local or local criminal statutes and their application to immigration laws. Okay. So normally you should not have a problem in a number of circumstances. If it's a one crime, one misdemeanor, it's hardly ever an issue. But I can't comment beyond that. I think you should get a consultation. Okay. Star 5 if you have a follow-up question on this. Star 5. Okay. Let's move on to the next question. Akanksha was on F1 Masters at Carnegie Mellon. For health reasons, had to take a leave of absence. Went to Canada. Want to finish my Masters. I'm going to University of Buffalo. 2 semesters for fall 2020. Applied for a new F1. I don't know if there's going to be a problem, Akanksha ji. It's totally up to the consular officer. They can decline to issue a visa for 1,000 reasons, and they don't even have to give you a reason. So the likely outcome is impossible to predict. But if you can show that you attended school for almost a year and that your dropping out was because of health reasons, at least you neutralize any negative implications. So you want to go online and then get OPT CPT after finishing your program. So as long as you have maintained student status for 2 full semesters, you are entitled to your OPT. CPT is a little questionable. I would steer away from it if you can. So the answer is, if you are considered to be maintaining student status, which is what the government said after they settled with MIT and Harvard, they said that they will consider you to be in status. I have no reason to believe they won't. So if they consider you to be in status, you can, after 2 full semesters, and become entitled to OPT. And CPT has a totally different set of rules. Star 5 if you have a follow-up question. Star 5. Vijay rocks having a baby. Congratulations. Parents want to come to visit US August end. They have a visitor visa. There's no restriction. That's right. There's no restriction on visitor visas. No potential questions. Look, this is what I suggest to people. If you have any idea that you are a little concerned about their ability to enter, get a flight that clears immigration, US immigration in the Middle East. That way, if you have any problem in entering, instead of flying back 20-25 hours, they only have to fly back 2 or 3 hours. Okay. Star 5 if you have a follow-up question. Star 5. Okay. And I repeat, we won't have time for new questions today. We are already out of time, but I'm going to finish the posted questions. So this is somebody who was scheduled for a naturalization oath ceremony, got a reckless ticket. Do I need to reschedule my oath ceremony? Well, it depends upon whether the reckless is criminal or traffic. If it's just a traffic violation, there's no problem. If there's a criminal violation, I think they ask you a question before the oath, or is it a form you fill out where they ask you about things that have happened while the case was pending? They can delay your naturalization if they so wish. But if the matter is disposed of favorably as a non-criminal offense, there is no problem. Okay. Star 5 if you have a follow-up question. Question number 17. USC has asked Congress for money to avoid furlough. Will immigration proceedings be delayed in case of a furlough? The answer is yes, they will be. Star 5 if you have a follow-up question. Star 5. Wife's H-4 EAD is expiring on July 31st. My employer is asking her to go on unpaid leave starting August 1st until she gets her new EAD card. Well, I see they are paying her for 1 month. I got it. She needs to exhaust all her vacation leaves before they put her on leave of absence. So she was planning to stop working. Okay, that's fine. Remember I talked about this if you heard the rest of the conference. It's okay for her to be paid for work already done. So if she stops working on July 31st but still gets paid till the end of August or the middle of August because she had leave accrued, I don't see any problem with that payment. Okay. Star 5 if you have a follow-up question. Star 5. Okay. This is Anjaneya. Came to the US, completed MS in computer science, moved to Bay Area, started working for company A on F1 OPT, switched to company B in March 2 years later, told company A not to file for H1, they filed it got picked in the lottery, it was approved. The DSO denied my request for I-20 and the college told me I was already on H1B and I didn't need an I-20. You guys, this is another thing that bothers the heck out of me. It's always bothered the heck out of me. Why? Because I could destroy your status if I'm the employer without your consent. And I think that's a lawsuit waiting to happen. I'm not a litigious person, but there are so many black holes in the immigration process. They need to be addressed. So an employee could inadvertently, without any volition, lose their status, F1 status, because the employer asked for a change of status on H1B. And then if they withdraw the H1B, you've lost status and you've lost your H1 as well. Consulates are closed. I can get a visa stamp. Filed for a change of status on 29th June. Received an RFE regarding the maintenance of F1 status. I think you should definitely argue that whatever the old employer did, they did without your consent. And there is a gap in the regulation that allows the employer to destroy your status without your consent, and that should not be allowed. Because tomorrow, if you end up taking it to court, you must have argued it before the USCIS. That's important. Okay? And I don't think you can get the service record fixed. If I were you, I would very seriously think about filing a lawsuit against the school as well as the USCIS. The school has to be made a party because they should correct your service if the government is not willing to back down on surrendering your H1 and putting you back on F1. So let me rephrase that. I think it'll take both parties, USCIS and the school, to complete the relief. How can I get my employment and get change of status? I don't think there's any other method, Ajay. I think you are stuck with this situation. Yeah, I see your hand up. Give me 1 second. I'm just trying to see if there's anything I missed. Let me just talk to you. Where are you calling from, Ajanya? Or is it Anjanya?
Hi, Raj.
Yeah.
Anjane. So, hi, Rajiv. I am calling from California.
Right. Go ahead.
So, the employer filed the H1B, it got picked, and then later when I came to know, the employer B was able to transfer the H1B in consular processing, but the change of request is denied, as you read out, with an RFE of maintaining of that status.
Right.
So, and I am currently on leave without pay since my EAD has expired, and I cannot return back to my home country, India.
Yeah,
so,
I personally feel you should argue compelling circumstances for loss of status. Not compelling, they call extraordinary circumstances beyond your control. You should argue that the employer should not be able to change your status without your consent, and you gave no such consent. In fact, you actually told them not to. And how can this is an illegal operation and procedure. The government must not consider you to be on H1. They have to put you back on F1 OPT grant you that status and grant it immediately. I would strongly argue that. I think you will win.
Okay, and any estimated timeline of how long the lawsuit, because it's hard for me to stay in US without an employment for a very long time.
See, when you file a lawsuit, first of all, I would not file this lawsuit from Washington, D.C. I would probably file it from California. Many lawsuits we file from Washington, D.C. because the government lives in Washington, D.C. And it's okay to file a lawsuit either in one of the three places: where you live, where the government lives, or where the events occurred. So when the events occurred out of California and you end up suing the school along with the USCIS, it may be better to file the lawsuit in California. But if you want to take a chance in Washington, D.C., worst case scenario, they'll move the case to California. I would probably not make the school a party, because if you make school a party, the case will have to be moved to California pretty much surely. I think chances are very high. But if they are not a party and we are challenging the government's policy, which is actually a standard policy, they do this with everybody. And I think it's an illegal policy. How can they affect you without your input? Chances are we might be able to keep it in Washington, D.C. Now, to answer your question about timelines. Lawsuit timelines depend a lot upon how hard the government wants to fight you. Okay, so if the government wants to fight, it can take a year and a half. But most times, if your lawsuit has a good argument, you might be able to convince the U.S. attorney, assistant U.S. attorney, the OSA, to drop the lawsuit, settle with you, and approve your case. Out of the 11 lawsuits we have passed and filed in the past few months, 9 were settled within a week. Okay, 9 lawsuits out of 11. The other 2 we just filed last week, so we are still waiting to talk with the OSA, and OSA has not yet been assigned. Okay, so chances are the resolution should be early unless the government wants to fight it. And if they want to fight it, I would actually move for what is called temporary injunction, also called stay. I would say that the denial should be stayed so that you can continue working while the lawsuit is going on.
Okay.
Okay.
Thank you, Rajiv.
You're welcome.
One more question. All of this should be done by my present company?
Well, I think this is one case in which you may not need the company because this affects you personally. But if they want to join, that is the perfect solution. I have an H-1B for a status issue. The 2 lawsuits that are pending, I think I mentioned it. One is an EB-1A, the other one is an H-1B status issue, where they have, in my view, misconstrued the regulations. Even if the employer had not joined, I would have filed that lawsuit, but the employer did join. So in this case also, you can pay the suit amounts, but the employer, if they can join, that would be perfect. If they cannot, I think you can still file a lawsuit. Okay?
Thank you, Rajiv.
You're welcome. You're welcome.
Thanks a lot.
Good luck. Okay. So we went kind of way over our time, but that's okay. Let's finish. This one is from Lucky. My I-130 got approved in April. It's with NVC. What do I do about the affidavit of support? My wife is an LPR. I'm not very good at answering these questions because I actually have to specifically review the law for each one of these situations. So normally you can have a joint sponsor who is not even related to you, as long as they are a US green card holder or US citizen. So it doesn't have to be your wife or your father-in-law. Okay. Obviously, if your father-in-law has not worked, that affects situation, but if he has enough bank balance or liquid assets, that might be okay. So these are questions that are very difficult to answer in the abstract. So theoretically, yes, his liquid assets can be used to support his sponsorship. Wife's unemployment, again, it can be a problem. How can you have a sponsor who's themselves unemployed and doesn't have the liquid assets to support you? And if she doesn't have any income, she has to say she doesn't have any income. Your wife, who's the sponsor, always has to be the one of the 864. She's got to be the first person. And I don't know, I haven't filled an 864 in years. The team takes care of that. I don't know what the difference between 64 Easy, 64W is. They bring to me for strategy, not for details about form filling. So I'm not going to be able to help you much here. I have to look at the forms. It looks like Easy is simply a shorter version of the 864, which is how it is for tax returns, IRS forms. So I can't really help you much. I would suggest get yourself a local lawyer, talk with them. It certainly is a very tightly fact-bound situation. I can't give you generic answers. So *5, if you have questions that I might be able to answer, I doubt I can. *5. Okay. Let's move on to, I think, the last two questions, and then we are done. Sarah says, my approval is till June 2021 through my current employer. Location has changed. They filed for amendment. I'm assuming we are talking about H-1B. Now I've got a full-time job offer, a new job offer. So can they, should they wait till the amendment is approved? This is the classic situation. I've discussed it twice already today. So when your original H1 extension has expired, an extension, original H1 period has expired, an extension is pending, technically you can file another transfer and move over to the new company. But government has this, in my view, illegal policy of not approving your H1B transfer if the H1B extension is not decided in your favor by the time they decide your H1B transfer. I think it's incorrect. I think you can fight it. You can check back with me in a couple of weeks. I am hoping that I can get the Assistant U.S. Attorney's Office to see my point of view, and they might not want me to fight on this case because I've got a lawsuit pending on exactly this situation. And if the amendment is approved, or maybe the transfer amendment is approved, will the original petition be invalid? No, no, no. So let's say I'm working in California, but I want to move to Arkansas, and they filed an amendment to move me to Arkansas. Arkansas gets approved. I can still stay in California because the California is not automatically revoked. I'm planning to join the new employer only after the H-1B transfer is approved. What day will be counted as I joined the new and stopped working for old employer? The day I signed the I-9? No, the day the H-1B transfer is approved doesn't matter. It's the day you actually join them. So maybe I would say the I-9. So yeah, that's legally acceptable. So let's say that I have one H-1B with the current employer and a transfer is approved. I can still give a 2-week notice or a 3-week or a 4-week notice and join the second employer 3 or 4 weeks later. I don't think that's a problem at all. *5, if you have a follow-up question on this, Sarah. *5. Okay. Oh, I still have, oh wow, 2 more questions. Oh. All right. So I came to the US on B2. I-94 is good till 21st July. I guess it's already expired. I applied for an extension in June. Oh, good. 6 more months. If you leave USA while the extension is pending, the extension is considered to be abandoned. But that's not the end of the world. That's quite okay. Just keep documentation, a copy of your receipt, copy of your filing, copy of your forms. Just scan and keep it, because when you come the next time, they could say, why were you staying? And if you say, I was staying here because on the basis of an extension application, I couldn't travel out. So the answer is you can leave, no problem. That application is gone, but keep a copy of the proof that you filed such an application. *5 if you have a follow-up question on this. *5. Okay. And this is the last question. Wow, that's a long one. My initial OPT ended July 16th of this year. STEM OPT got approved for 2 years. I have the receipt notice. There's a 3 to 4 week delay in EAD card printing. I have a 1-year contract with current employer. Changing employers. My STEM OPT began on July 17th. If I change employers, I need to submit final evaluation form 983 for current employer and new I-983 for new employer. I don't expect the current employer to sign the final evaluation. And current employer might also avoid paying my salary. Okay. So, look, I can't comment about employment laws. That's not my field. And employment laws are also, they can be very specific to a particular state. There are federal as well as state laws. So I can't really comment about employment laws. Is it okay if I put my resignation date for current employer July 16th? My initial OPT ends on July 16th. The answer is if you have worked till July 23rd, you should, whatever the truth is, stick with the truth. You can't change things around. Since I can do volunteer work on initial OPT, I'm not expecting current employer to pay salary for the month of July. Is it fine? You have to tell the truth. Look, don't make things complicated. Whatever the truth is, don't try to juggle things around to suit yourself. Tell the truth. And if you don't get paid, file a complaint with the Wage and Hour Division and with the local employment services of the state. Ask them to recover your money for you. That also gives you defense against any violation of status allegations by the USCIS. You filed if the employer doesn't pay, what can you do? Take a gun to them and get it from them? You cannot. So just take legal action, free legal action by filing complaints with the proper government agencies. And you can be unemployed for a certain number of days. What is it? I think it's 90 days you can be unemployed while you're on initial OPT. Then during the 2 years of STEM OPT, you can be unemployed for up to 60 days, I think. I don't have any suggestions other than to say that stick with the truth, whatever it is. You cannot manipulate facts. Many of these forms, in fact, if not all, are filed under penalty of perjury. If you tell the truth, maximum you would happen is people could, or the government could come after your status. But if you tell a lie, you can go to prison. And you can certainly be barred from entering USA forever. Okay. So this was the last question. Don't have time for new questions. *5, if there's a follow-up question on this. *5. Okay. Let's see. Where are you calling from? 848?
Hi. I'm calling from Virginia.
Okay.
And first of all, thank you very much for all those answers. I know it's a lot, but outside your time frame.
No problem.
Really thankful
No problem.
for this free service. I do have one question. You said there's a way to freely ask the government to pay. Like,
Oh yes. Oh yes.
I don't care about the salary.
No. It's actually also a defense for you. It's not just the money. If the government says, hey, you didn't get paid for XYZ period, first of all, you're allowed not to be paid. That's part of being unemployed, right? So certain period of time is not going to hurt you. But why should you let go of your salary? So what you should do is, there are 2 levels of agencies. I don't think Wage and Hour Division would interfere, but they might if it is a STEM OPT. They always intervene when it is H-1B. Okay. But salaries are also the responsibility of the local employment agency. Like in Virginia, it's Virginia Employment Commission. You can call VEC and say, look, they're not paying my salary. They'll take care of it.
Okay, and again, because I have signed the contract, it says like I have to stay here for another year or something, like 1 year. Right? How good is this contract?
Well,
I mean, I've heard it's like,
see, luckily you're in Virginia. Luckily you're in Virginia, so I can comment about Virginia and DC laws. I can't comment about other laws. So contracts for employment are valid unless they are unconscionable or there are some exceptional. I can't comment about a contract without looking at a contract, and I'm not an expert in employment law, so you should talk with an employment lawyer. But generally speaking, contracts for employment are valid if they are reasonable. Okay.
I mean, it says in the contract they won't pay me if.
I can't comment about that. You can still, it doesn't hurt to ask the VC to look into it. VC could say, sorry, you have a contract, but you can at least ask them. Doesn't hurt.
Right.
Okay.
Okay. And just small question: would you know anything about I-983? Like, there's the final evaluation that I have to submit.
I don't know exactly what the requirements are. I don't remember them off the top of my head. You can definitely talk with the school about the situation, see what they say, because they are ultimately the guardians of the 983. And my advice always is to people, in case you can't do full compliance, do the best compliance you can. If the employer refuses to sign it, you can just submit it the way it is and tell, or at least put a cover letter saying, hey, because I'm leaving this employer, they have refused to sign it. I asked them.
Okay. That is definitely helpful.
Yep.
Yeah. Thank you again.
Absolutely. And if you, another thing to remember is that if you have any communications with the employer, make notes of what they told you, the date and the time and who you spoke with, and do it right after the conversation. These are called contemporaneous notes. So take contemporaneous notes, they are evidence. Okay?
Okay.
That's what Comey did when he talked with Trump. That's what Comey did when he talked with Trump. Okay?
Okay.
Good luck. All right?
All right. Thank you.
You're welcome. Okay, guys, this was a much longer day than we normally have. Good luck to everyone, and I'll see you again in 2 weeks. It's always a pleasure to be with you guys. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.